Who has authority to sell probate real estate? Who has authority to sell probate real estate depends on legal appointment, not assumption. Control over property does not pass automatically. It is granted through the probate process. When a person dies owning real estate in their name alone, that property becomes part of the estate. From that point forward, no one has the right to sell, transfer, or manage the property until the court formally appoints a personal representative, also known as an executor. This appointment is the foundation of authority. The court issues documentation that confirms this authority. Without it, any attempt to act on the property carries no legal weight. Ownership has not yet been reassigned, and control remains under the supervision of the probate court. Once appointed, the personal representative is responsible for managing the property as part of the estate. This includes protecting the property, maintaining it, and making decisions about its future. However, authority does not mean unlimited discretion. The scope of power depends on the type of authority granted by the court. In some cases, the personal representative has what is known as full authority. This allows the property to be sold without seeking additional court approval for each step. Even in this situation, the representative must act in the interest of the estate and follow required procedures. In other cases, authority is limited. This means the personal representative must obtain court approval before selling the property. The sale process may involve filings, notices, and confirmation before it can be completed. The court remains directly involved in overseeing the transaction. The will, if one exists, may also influence how authority is applied. It may provide direction regarding the handling of real estate, but it does not replace the need for court recognition. The personal representative must still be formally appointed before acting. Heirs do not have authority to sell the property during probate unless they have been appointed as the personal representative. Interest in the property does not equal control over it. Authority is tied to legal appointment, not to who is expected to receive the asset. If multiple individuals are appointed, they may be required to act together depending on the terms of their appointment. This can affect how decisions are made and how the sale process is handled. Before any sale can move forward, the personal representative must also ensure that the property is properly identified, that title is clear enough to proceed, and that any obligations tied to the property are understood. These steps support the execution of authority but do not replace it. When the property is sold, the proceeds do not go directly to heirs. They are placed into the estate account and used according to the estate's obligations. Authority extends beyond the act of selling. It includes handling the outcome of the sale within the structure of probate. Throughout the process, the personal representative must document actions taken and comply with court requirements. Authority carries responsibility. Every decision related to the property must be supported by proper process and record. Who has authority to sell probate real estate is determined by one principle: legal appointment by the court. Without that appointment, no action can be taken. With it, the process can move forward within the limits set by law. This content is provided for general informational purposes only and does not constitute legal or financial advice.